The Seventh Circuit U.S. Court of Appeals issuing a mandate in the case challenging Illinois' gun and magazine ban. What does that mean? From my understanding, it means that it just is now official. The mandate has issued. Now it's time for the district courts to head back and discuss the case. So welcome back in Bishop on Air. I'm Greg Bishop. Cover the Illinois State House for my full-time gig. Doing this each and every weekday morning is just me kind of hanging out with you. So I appreciate you guys being with me every morning and checking in. But with this case, we've been tracking it since January 10th when the governor enacted the bill to the lawsuits that followed in state and federal court and all of the ins and outs. If you guys have been watching all this time since well, even before January 10th of last year, then you're really, hopefully getting a lesson in how these court cases play out. So just to recap, all right, so we've got the Seventh Circuit U.S. Court of Appeals that back in November, they finally issued their ruling after hearing the case 4 months in advance from the Southern District and the Northern District courts in Illinois. And those two different district courts had different outcomes on preliminary injunctions. You had requests from the Southern District plaintiffs groups that was advanced. You had Judge Stephen McGlynn in the Southern District issue a preliminary injunction on Second Amendment grounds. But in the Northern District, you had different judges in district court side with the state saying that they had a likelihood of succeeding on the merits. So again, these were all preliminary issues that were combined into the Seventh Circuit. And you have one of those cases, the Beavis case, attempt to try to get the U.S. Supreme Court to intervene before the appeals court actually consolidated all those cases. But once the appeals court consolidated those cases, this was this past summer, then you had the U.S. Supreme Court essentially say, go ahead and continue doing what you're doing. Appeals court. The appeals court heard the case, and a lot of the argument was about, these firearms being similar to military weapons, and even the ruling that came out indicated that if the military was to incorporate a firearm into their catalog, then they probably shouldn't be available to the public, which was an interesting kind of aside. But really, a lot of the questions about the Second Amendment issues that the Seventh Circuit dealt with, what's commonly used, what is possibly a banned firearm, but all of that was on the preliminary injunction. So the Seventh Circuit ruled in November. Then you had other action in the district court in Southern District on other issues, not the Second Amendment issues. You had Thomas Magg bring arguments that it was unconstitutionally vague, and you also had the Federal Firearms Licensees of Illinois bring a separate challenge trying to delay that January 1st deadline. So all of those things played out, right? And during those hearings with Judge Stephen McGlynn in the Southern District, both the Mag case and the federal firearms case, the judge said that he has yet to see the mandate from the Seventh Circuit. He says the mandate has yet to issue. Well, we get that issue on the 3rd of this week. So I didn't see that yesterday when I was checking all my cases. But on January 3rd, the mandate was issued. So let's go ahead and take a look at this from just my notes here, my show planner. Went ahead and grabbed it from the official docket for the Southern District. And it says, notice of appeal. Wait, let me see here. Motion for summary judgment on the 19th. You've got... I grabbed the wrong thing here. All right, either way. So ultimately, the mandate issued. Let me see if I can find it over here and pull this up. All right, here's the actual mandate that was issued. All right, so we look at this, and of course, it gives a little bit of an overview and what's ultimately happening with this case. But it says that we affirm the district court's orders denying preliminary injunction in a set of cases, and we vacate the district court's order granting preliminary injunction relief. We also confirm that the stay we issued in these appeals will remain in effect until our mandate issues. The above is in accordance with the decision of the court. So the mandate ultimately issuing yesterday, on the 3rd of January. So what that means is it goes back to the district courts now officially. And in the Southern District of Illinois, Judge Stephen McGlynn resetting that hearing and the Fifth Amendment arguments now in the Southern District of Illinois. And these are the arguments that Attorney Thomas Magg brought forward. And that was the arguments that Ultimately, this is a violation of the Fifth Amendment for people having to register their firearms. But I imagine we're also going to get into a lot of the other merits of all of these cases. So yes, the mandate issues, and then the judge, Stephen McGlynn, he set that summary judgment on Fifth Amendment issues motion for the government to respond by January 19th. But you've also got a status conference in that case on January 12th. So key dates to remember there. But something else, too, is you've got earlier in December in the Canel versus Raul case. This is the case from the McHenry County State's Attorney's Office challenging the state's gun and magazine ban. Because as we've heard, there's a lot of prosecutors, state's attorneys, locally elected state's attorneys across the states that are not going to be making this a top priority. Even, Gun Save Life, highlighting that you've got Sangamon County Sheriff Jack Campbell reaffirming that he is not going to enforce this. And they're quoting a State Journal Register article and others who ultimately show that, the sheriff says that we disagree constitutionally with this law. Our plan is to move forward and use discretion and educate people on what the law says. So it's kind of an interesting way to approach it, saying that they're just going to educate people about what the law says. But you've got others saying it's not going to be a top priority and they're not going to enforce this. But ultimately, you have Patrick Kenneally's case where you do have the judge there essentially saying, and I'll pull this up because I'm pretty sure I've got this in the correct spot. The judge in the Canel case says, since the completion of briefing, the Seventh Circuit released its opinion in Beavis v. Naperville. The court recognizes that the case presented to the Seventh Circuit was based on interlocutory injunctive rulings. These are, in the middle of the actual case and not yet in the definitive end of the case. But the parties might want to address the Beavis decision because the court is certainly going to consider it. So the parties are given leave to file by January 11th a 5-page brief relating to the Beavis decision on the pending motion. So the Canel case is still active, and the judge asking for briefs to discuss how the ruling out of the Seventh Circuit impacts the Canel case, the McHenry County State's Attorney's case. So that's interesting. We'll keep watching that as well. But that's not the only place. You've got even the U.S. Supreme Court today. They're expected to possibly take up the case that State Representative Dan Caulkins had in front of the Illinois Supreme Court. And if you recall all of that in the state courts, Caulkins filing a challenge, getting a final ruling in the district court. It skipped over the state appeals court and went right to the Illinois Supreme Court. And they argued violations of special legislation and also violations of equal protections because of the different classes of people here. After the Illinois Supreme Court, number one, denied a recusal motion, number two, sided with the state, you had Caulkins take the case to the U.S. Supreme Court. And while the U.S. Supreme Court declined to, midway through the case, intervene and give an injunction against the law, they did forward the case to conference. So Justice Amy Coney Barrett, overseeing this circuit, did indeed forward that to the conference of the Illinois Supreme Court. And what is a conference? If you look at the Supreme Court's website when it comes to their schedules and whatnot, you can see here it spells out what their conference ultimately means. Conference days, the justices meet in private to discuss cases argued earlier that week. The justices also discuss and vote on petitions for review. The building is open to the public and blah. Okay, so ultimately, again, they're going to review possibly taking on the Caulkins case. Will we know tonight what the outcome is? I don't know. I did have somebody who's watched these things pretty closely tell me that they may not release, the kind of order sheet Friday. You might actually get it Monday. So we'll watch that and see what happens with today being the U.S. Supreme Court going into conference and possibly deciding whether or not to take up the Caulkins challenge. But Dan Caulkins, when we talked with him a while back, he laid out why this case is important. It's not just the gun ban. It's also the conflict of interests issues that the Illinois Supreme Court denied and all of the questions that were there. So here's Dan Caulkins chatting about this last month.
we sent a recusal request to each of the two judges that had recently been elected, Democrat judges, who were elected in districts that the governor signed into law, that the House and Senate majorities drew for them, so that they would get to keep their two Democrats on the Supreme Court. Additionally, what happened during that campaign was that Governor Pritzker gave each of them about $1 million. We can debate the legality of that. Plus, the Speaker and the Senate President gave hundreds of thousands of dollars to each of these candidates. And under the Caperton precedent that the U.S. Supreme Court had set, we felt there was, if not a genuine bias, there was an appearance of bias that the public and we as plaintiffs didn't feel that we had an opportunity to have a fair hearing. The two judges flatly denied our request that they recuse themselves. Wasn't unexpected. But the way they did it was rather curt and impolite, but it serves us well at the U.S. Supreme Court now.
So again, the case at the U.S. Supreme Court in conference today. What could they possibly decide? We shall see. But more from Caulkins talking about, again, the importance of this case.
Well, that's exactly the case, Greg. When our recourse, our only way to redress what we think are unconstitutional laws is through the court system. It's been through the legislative and executive branches, and our only recourse then is to go to the judicial branch. And when the perception, and I say that the perception is that the judicial branch is biased in favor of the executive branch or the judicial branch, or in this case, both branches, people are denied their rights. This is an affront on, and I say the small r, this is an affront on our Republican form of government, separation of powers. So really, that was why we took this case to the U.S. Supreme Court.
We'll be watching. We'll see what the U.S. Supreme Court ultimately does with the Caulkins case going into conference. So that's just a snapshot of sorts of the latest in some of the litigation we've been tracking here. But, of course, that deadline of January 1st came and went, and the registration totals before that January 1st deadline ended up being, about 30,000 individuals registering 60 some odd thousand firearms and 100,000+ attachments and like 500 some odd 50 caliber ammunition. That's 1.1% or 1.22% of the state's 2.4 million FOID card holders. And I know a lot of you have been asking and emailing and messaging me, and even in the comments, why haven't the FOID card numbers gone up? I haven't seen those FOID card numbers go up in the past 3 months. I do have a question that I sent Illinois State Police. I'll have to reply to that email to see if they respond, but they did not answer my question as to why those numbers have not changed. Why the FOID card numbers, not the number of banned gun registrations. Those have gone up at 1.22% of the 2.4 million FOID card holders. That 2.4 million number has not changed in the past more than 3 months that we've been checking these things. So we'll see if we can get an answer to that. But ultimately, you have the Illinois State Police also given some statements to a variety of outlets. In particular, you've got WAND doing a story about the former state senator Darren Bailey missing that deadline to register a weapon, and the State Rifle Association sharing frustrations, and ultimately they have the Illinois State Police talking about what kind of prosecution there could be. An Illinois State Police spokesperson said, as with any violation of the law enforcement authorities will work with states' attorneys on search warrants and charges, and the circuit court system will determine penalties pursuant to the act. And that's really what we heard during the public hearings on the Protecting Illinois Communities Act, that was going to be up to local law enforcement. But also you have locally here in the Springfield area, News Channel 20, they had a report as well, essentially saying that Illinois State Police aren't going to pursue charges of those who register weapons after the January 1st deadline, which is kind of interesting because, you know, the law clearly states that the deadline's January 1st. The window is open October 1st. The deadline to register was January 1st. But according to News Channel 20, they say that ISP does not intend to act against residents who file an endorsement affidavit after January 1st. The FOID portal will remain open, and people can submit endorsement affidavits at any time. ISP's goal is compliance with the law and safety. And even Illinois State Police, during public comment period, they said that the registry will remain open after January 1st. But the law clearly says January 1st is the deadline to register. So if people end up registering, January 10th? Are they incriminating themselves? And they're going to have to check that box that says that you're registering voluntarily. So some interesting things happening in as far as different statements that are going out. But that's the latest here with what's going on with litigation on the state's gun and magazine ban and where we're at in the enforcement of it. But of course, if any of you hear things and see things on this or any any subject of news, email me. All right, bishoponair@gmail.com. bishoponair@gmail.com. It's a great way to get hold of me. I know some of you have called me during the workday, and I'll answer. But gosh, I gotta be quick because I've got tons of stuff going on in my full-time gig. So appreciate everybody's support, and again, send tips. bishoponair@gmail.com. bishoponair@gmail.com.